Good afternoon, and thank you all very much indeed for joining this Pegasus Group and Keating Chambers webinar on the Planning for the Future white paper. Let's start by introducing ourselves. So I'm Charlie Banner, QC from Keating Chambers, a barrister specialising in planning and other associated matters.
I'm Gail Stoughton. I'm an Executive Director at Pegasus Group, and I lead the heritage team there.
Hi, I'm Neil Tiley. I'm a director at Pegasus Group, based in the Cirencester office, and I specialise, broadly speaking, in housing need and supply.
I'm David Hutchison. I'm also an executive director at Pegasus, and I specialise in particular on development management in terms of applications and appeals.
Thanks, everybody. I should say the flyer did indicate that Andy Cook of Pegasus was going to join us as well. Unfortunately, for compassion reasons, Andy can't join us, but hopefully we'll do a good job in his absence. I'd like to say a few words to start off with about the purpose of this webinar. I'm sure pretty much everybody watching this would have seen adverts for countless webinars and presentations on the white paper, looking at its merits, looking at its contents, and many of these have been absolutely fantastic. What we want to do is something a little bit different, because by now really everybody knows the arguments for and against the proposals, and everybody knows what the proposals are. So what we wanted to do is to look at a little bit more depth as to what the regime proposed by the white paper will look like in practice. What will its implications be? Where do the opportunities lie for our clients? Where do the challenges lie? Necessarily, in some respects, where the white paper is light on detail, there's a degree of supposition involved as to what is likely to happen. But in a number of respects, it's fairly clear what the future regime will or may hold. So that's the intention. Please do contribute to the discussion. I imagine everybody by now is familiar with the Q&A function on Zoom. I'll keep an eye out on questions or comments coming in on that as we go along. In broad terms, we're going to structure the discussion under three main headings. So we'll start by looking at plan making and a number of topics within the context of that. Then decision making, and then finally we'll look at the new infrastructure levy and what that might mean for viability and other associated matters. So kicking off with plan making first of all, and obviously the antecedent issue before the local plans are prepared is what is the housing requirement that each local authority is to be required to plan for, and now that's going to be resolved before the plan making process in order that the plan process itself can be streamlined. So Neil, you're going to kick us off on this one as the resident expert on housing supply matters. So I'll hand over to you to open the discussion on this subject.
Thank you, Charlie. It's widely known and recognised from long experience that under the current planning system, we just simply haven't even planned to address the actual housing need nationally. And that's in no small part why we find ourselves in the situation we're currently in, namely the deepening of the housing crisis. The white paper has proposed a set of fundamental reforms to address that issue, and those are to be wholeheartedly applauded. In particular, it proposes to set a binding housing requirement for every local planning authority, which will, in combination, address the local housing need, the national housing need. By setting a binding housing requirement, as Charlie's already alluded to, it will speed up the plan-making process, and in turn, that will speed up the allocation of sites and therefore the delivery of sites. And an important benefit that I'm not sure everybody has quite appreciated is the clarity that it brings to everybody. So if you're a landowner or a promoter or a developer, before you take on a site, or if you're already engaged in a site, you know what the housing requirement will be for your patch. So you can assess the prospects for that site coming forward, or the requirement for that site coming forward. Similarly, if you're a plan maker or a local community, because you understand that overall figure, you've got a much better basis upon which to prepare a plan or think about the appropriate distribution of sites. And similarly for infrastructure providers and statutory consultees, because you know the level of housing required, you can begin to think about the infrastructure required and the appropriate mitigations that might be required to accommodate that. Therefore, these reforms, which really are significant, should really be applauded. However, the real challenge that the government has set itself is to identify a sustainable distribution of those binding housing requirements. The white paper provides a bit of detail in that it lists a series of factors that will be taken into account in determining that housing requirement, including things such as housing need, development constraints, development opportunities, and an appropriate buffer. Now, those are all broadly reflective of what is already taken into account when determining a housing requirement and provide a credible basis. The one omission that I'd say is missing from that list is regard to sub-regional interactions. But assuming that those are added to the list, the government has also come up with a credible basis for determining these housing requirements. The real challenge is processing those competing factors in a meaningful way to provide for a sustainable distribution that responds to the individual circumstances of different LPAs. Now, that is a really formidable challenge, and one which I wouldn't like to have to address. But I understand that Charlie has some thoughts on how that can be made less formidable, so I'll hand back to Charlie.
No pressure, Neil. Thanks for that. Yeah, I mean, the critical issue is assuming that the white paper proposals happen in some shape or form, as I believe that they will. So taking that as a premise, how do you strike the balance between, on the one hand, allocating each local planning authority's housing numbers more quickly and efficiently than is done now, but on the other hand, allowing for sufficient stakeholder involvement and scrutiny so that the outcome is sufficiently informed and has legitimacy. That's the task. And I'm going to outline a process which has been suggested at very high levels, two very high levels, I should say, of government at MHCLG. And I think it wouldn't at all be surprising if something resembling this ended up being the system. So the starting point is you divide up the local planning authorities in England, because of course these reforms only apply to England, into what might be called housing delivery areas. And they don't have to be called that, but that's the name that this proposal has suggested. In areas where there's a mayor, so take, for example, West Midlands or London, then the housing delivery area would be the local authorities within the mayoral region, for simplicity. In areas where there's not, then the central government body that's responsible for dealing with the housing requirements. It's not yet completely clear whether that's going to be MHCLG or Quango or a committee that has MHCLG and Treasury representation. I think the latter might be the favourite, but whichever that body is, they would work out what the HDA should be for non-mayoral areas, having regard to geographic, demographic and economic factors. Critically, what you wouldn't do, which is done now, is you wouldn't split local authority boundaries in the way that housing market areas do, and that causes more complication. Yes, it would be a little bit more rough and ready, but that's the price of getting it done more quickly. So once you've worked out the housing delivery areas, then the relevant central government body would allocate a number to each housing delivery area based upon its algorithm, if we're allowed to use that word still. But that would be a provisional. It wouldn't be binding straight away. It wouldn't be final. It'd be a provisional allocation. And then the local authorities within the housing delivery area would have a very strictly time limited opportunity to adjust the distribution between themselves. And it may be as short as something like 28 days. It may not, maybe a bit longer, but that's again what the proposal that's been put to government is. And there would be conciliation, so there would be some kind of individual appointed to chair that process of discussion between the local authorities, whether that's a planning inspector, a mediator, or whatever, doesn't really matter. Then there's one or two options. Either the default is if they can't agree within 28 days or whatever the time it is, then the provisional figures given to each area within the HDA would take effect, or it would be up to the mediator to decide which whether to make any fine tuning to the figure given to each authority within the HDA. So there'd be that process. It would be time limited. It would be focused. It wouldn't be a formal legal process. There wouldn't be endless submissions. It'd be focused, and there'd be a guillotine, an absolute guillotine after whatever the time limit is, when either the provisional figure would kick in by default, or there would be an imposition by the conciliator. The conciliation process ought to involve a representative body of developers and land promoters, so it's not just local authorities in play. It's moot whether you might want to add one representative body of the local community as well. They might be thought that that's the function of the local authorities to represent their communities, but it wouldn't be a free-for-all. It would be a focused number of participants, so as to keep the process on track. And then as a public body's decision, ultimately the allocation of numbers to each local authority would be subject to judicial review. You can't get rid of that, but there may be scope for reducing the number of people who could bring a judicial review. So it would have to be one of the participants, one of the local authorities, or the developer land promoter representative body. And there may be scope for tightening up the timescales for judicial review. So you have to bring it within 2 weeks, for example. So something along those lines has been put to government, and I know is being considered. And to my mind, something like that, with perhaps a little bit of adjustment on further reflection, would strike that balance between getting a figure for each local authority quickly, but giving enough involvement to the main stakeholders and enough scrutiny that the outcome wouldn't be massively incongruous and it wouldn't lack legitimacy. So that's my start of 10. Very interested to hear what anybody might have by way of comment on that. One of the elephant in the room, of course, in all this context is constraints, and how do you deal with constraints? The white paper is deliberately silent, really, on Greenbelt, but of course that's something that could be dealt with through guidance or policy after the legislation introducing these reforms has happened. I don't know if anyone's got any comments before we move on to the next subject about how you would deal with constraints in this context.
Charlie, just a few observations and queries. Well, firstly, the proposal of HDAs should deal with those sub-regional interactions, which I was saying, because you're assessing a need for a combined area, and then you can take account of how those LPAs within that area interact. So that's a real benefit of the proposal. Just a quick question: have you got? Obviously, you highlighted London and the West Midlands, which are quite large areas. But have you got any feeling for the scale at which housing delivery areas might be? Because, say, for example, just pops into my head, Isle of Wight, I assume, would be a housing delivery area by itself because it's quite isolated. But there's quite a big discrepancy between the size of the Isle of Wight and London. So do you think there'd be a huge range between a range?
I think the honest answer is no. It was plainly going to be variability across the country, given the varying sizes of local authorities. I'd have thought what I have in mind generally is about half a dozen, give or take.
Yeah.
I think that's a workable number. Any more, and it's going to become like rabbits in a sack, and it's going to be impossible to manage. And any less, it sort of then becomes, then the whole point of it is lost. So that's the sort of order of magnitude I have in mind. But there'll be a little bit more in some cases, a little bit less in others, I imagine. Yeah.
Sorry, coming back to constraints, the actual trigger. That's how interesting how that interplays with housing delivery areas, if that's what comes out in the wash. In that, whether you take the constraints into account before setting the combined housing requirement, or whether you set the combined housing requirement and then let those grouping of authorities deal with the constraints but still meet the housing requirement. That'll be fascinating if this proposal is taken forward, to see how that plays out as well.
What I think it might do is actually temper the risk of challenges, because if it's simply done as a top-down, it's some Whitehall committee that says this is the number for every local authority and that's it. I mean, it's great news for judicial review lawyers. We're going to be very busy because everyone's going to chat. There's every area is going to have at least one person unhappy with the product. And I think if you have a degree of input and involvement along the list lines, without it being a protracted process, it might engender sufficient legitimacy amongst key stakeholders that you get fewer challenges, or such challenges as there are can be weeded out pretty quickly because the arguments have been ventilated, at least in summary form. Should we move on to the next sort of step? So in this brave new world, we sort out the housing numbers. Let's assume by hook or by crook, the national allocation of housing numbers to each local authority is done. And then it's time for each local authority to put together their plan. And I suppose the first question is, what do the housing numbers for each area mean for the amount of other growth? And for example, employment, how does that work through? And Neil, as our resident economist, what are your initial thoughts on how might that work?
Well, yeah, I mean, the first observation is that the white paper is very housing focused. So there's not a lot of detail on the needs for other forms of development. But I think there's a bit of a window there. The white paper proposes that the standard method for determining the binding housing requirement will be informed by the need to accommodate other forms of development. Now, that infers that the government will have some standard method for at least identifying the likely need for other forms of development, even if just as a broad proxy, in order to inform the standard method for the housing. Now, I mean, that might seem very crude, but actually, if you think about it, for the majority of forms of development, there is a correlation between housing requirements and the needs for those other forms. So, for example, if you have more housing, you're likely to see more land for infrastructure, or whilst it's more tenuous, there is a link between the need for housing and the need for employment land. So therefore, once this new standard method for determining a binding housing requirement comes out, reading between the lines, we might be able to infer what the starting point is for other land uses. And that we might be able to use that as an insight to, if you've got a client who's looking to promote employment land, for example, it might provide a bit of an insight for where the government, at least as a broad indication, think the employment land needs might be for that LPA. There is one complexity to that, which I'll very briefly address. There are some forms of development which aren't remotely linked to housing requirements, such as the need for solar farms is the obvious example. The white paper is entirely silent on those forms of development, and the ability to accommodate those can't be kind of introduced into the standard method. So that remains a watching brief, but I will keep attentive to see how the white paper evolves, to see how you establish both the needs / requirement for those forms of development and how you then plan for them thereafter.
It's a very good point. I mean, you can't, even the best way, you can't plan for everything. It's just not possible. One point we're going to come on to deal with in the decision-taking section is how in future will it be possible to promote development that's not in the plan, either because it's not earmarked in a growth area or renewal area, or because it's something that's in one of those areas but not the kinds of developments that are annotated in those areas. And I think there's two categories of issue there. One, stuff which could have been planned for, but the decision was taken not to, and the plans have come out of date or whatever. And two, something which wasn't planned for in the first place because it's unplannable. You wouldn't ordinarily, I think, you wouldn't allocate a site for a solar farm. It may have happened in the past, but ordinarily that's kind of not really how it works. So yeah, I think that's a very good point. We're going to talk now a little bit about the three categories of areas that the white paper talks about: growth areas, renewal areas, and protect areas, before we look at the plan process. And initially, I think one point I always wanted to highlight is, on the face of the white paper, there's a degree of tension between the description of some of these areas. We're told that the protect areas are going to be, as the name suggests, areas containing areas or assets of that need to be protected, conservation areas, green belt, AONB, listed buildings, etc. But on the other hand, growth areas may well impinge on some of those protections necessarily, because plainly, as has always been the case, when you release land for growth, some of that land may have a degree of constraint on it. So quite how there's an interplay between the growth areas, which get their automatic outline planning permission, and protected assets is going to be an issue. And I think we'll come back to the plan making process. We're going to talk a little bit more about the heritage implications of that. But Gail, did you have any sort of thoughts about how how that interplay between growth areas and assets, particularly heritage assets that might need to be protected that fall within those areas, how that's going to work.
Yes, I mean, I think the primary concern is if the same aspects are going to be taken into account as are currently considered in the NPPF, and it does seem to be the case. So built heritage is definitely still a consideration. It's explicit in the white paper, and there are also around about 19 photos of historic buildings and areas in it. It's implicit as well. And archaeology, whilst it's not mentioned explicitly in the white paper, the IFA, the CIFA has put out a statement saying that government has given them assurance that archaeology will still be a consideration. So if those two things still need to be considered, it's knowing the quality of the data that's gone into making it, because if the approach is taken, as seems to be advocated, of mapping lots of things so you know where they are to take the decisions, that's likely to be quite a broad brush exercise necessarily, because of course you can't map everything. There are many things that are likely to lie outside of a really broad brush consideration. So broad brush consideration might focus on local lists, as funding's recently been announced for local authorities to create them, but those are visible things and tangible things that people can actually see and assess straight away. There are things that are going to lie beyond it. So there'll be unforeseen archaeological remains, and there'll be things like the setting of heritage assets. You know, if a broad brush approach is taken, if things like essential setting, the concept of that, you know, is established in Wales, if things like that are plotted, then it's just being cognizant that there may be issues outside of those broad brush plots that are still risks for development. So things like unforeseen archaeological remains, or the setting of heritage assets, which needs detailed analysis to get to grips with. There can be, you know, case law is extremely clear that it goes beyond purely visual factors. So there may be economic links and things like that that only come out later on. And if the detailed permission further down, if that broadly has to be compliant with the level of harm established in the plan making process, then there is a risk there that things may come out further down the line. So there is a bit of tension in that. It's knowing the quality of the data on which decisions have been taken.
Thanks, Gary. A point that's probably worth noting at this stage, we might come back to it a little later, is my understanding of how the new regime is going to be given effect in legislation is the whole body of law relating to plans is going to be repealed and recast. So the 2004 Act in particular will be done away with in relation to plans. But the Town and Country Planning Act 1990, the main elements of that in relation to decision taking, and the List of Buildings Act will be unaffected. So effectively, the output of the plan making process in the new regime in a growth area will be outline permission, but that will be an outline permission within the meaning of the 1990 Act, and then all the consequences under the 1990 Act flow from that. And one thing that means, and in particular the not touching the List of Building Act means, is that under Section 66 of the Planning Listed Buildings and Conservation Areas Act, the statutory duty to have special regard to the objectives of preserving and enhancing listed buildings and their setting only applies to the grant of planning permission. Doesn't actually apply to the plan making process. Actually, funnily enough, in relation to conservation areas, it's cast a little bit differently. In relation to the list of buildings, it's considering to grant planning permission. And although there is the policy requirement still in NPPF, the statutory duty, which is what carries the considerable importance and weight, only applies to planning permission. But of course, if the plan making process is granting planning permission under the 1990 Act, the statutory duty becomes engaged where it previously wasn't, which probably means that Gail's going to be rather busy, I have thought, in the next few years.
If you have to comply with the Act, then cases like Mordew show that in order to do so, you have to go through the public benefit balance as required by the NPPF. But of course, that requires all of the articulation of significance and impacts. So in order to get that level of information at the point that decision is made, you would have to front load a very nuanced setting assessment, which, that will keep us all busy.
Absolutely. Whereas before, it tends to be in EIPs, it's a much coarser grained approach to heritage, and then it all comes out in the wash at the decision stage. David, from sort of your planner's perspective, how do you see, again, starting with growth areas, issues such as phasing and distribution work? So you have the growth area, a big sort of area on a plan, and there's various uses annotated as appropriate for it. There's outline planning permission for it. What happens next?
Yeah, obviously the growth areas are these areas for the substantial development, and as you sort of indicated there, it's going to be the strategic urban extensions, new settlements, potentially anything that requires that comprehensiveness of planning. Now, everything that the white paper is telling us is all about streamlining and trying to simplify the process. Certainly by being granted outline planning permission at the allocation stage is going to do that. But I think there's going to be an expectation from industry to say, well, can I just take my product off a shelf, put it on the land because it's ready to go? In terms of phasing and so on, I think we're certainly going to be trying to avoid that situation we were in back in the 90s and early 2000s when sites were being told you've got to come forward before another site and so on. But I think it's inevitable that even when you have a site, the site itself, you're going to have some sort of sequencing of development. It would just be illogical to allow phase 10 to come forward before phase 1, 2 and 3. So I think what we'll still have there is a sequencing of how schemes could come forward. But I think probably our experience in dealing with larger urban extensions kind of flows into this, because I think you would probably still have perhaps an infrastructure application that would come at reserve matter stage. That would then allow for effectively service parcels to be set up, and then you could allow different parts of the site to come forward. And then you would, as part of the text or the conditions of the allocation, you would anticipate that there would be triggers that will be set there to say, well, once you've built 300 houses, perhaps the primary school ought to be coming online or something like that. And therefore, there will be these things that could be set out in the text to go with the allocation. The thing that I suppose is going to be interesting also is just to understand how off-site infrastructure is dealt with, because obviously a large development on one side of a town may require some off-site improvements elsewhere, and how that could be dealt with. But again, I suspect it's going to be the text and conditions of the allocation, and that could be dealt with. So when we then come to the how development would be distributed, I think probably the best way of envisaging this would be like parameter plans that we have with the large outline schemes. So they're going to be identifying where those land uses are. So identifying, let's say, the residential parcels and so on. I think the difficulty that we're going to have to get our heads around is what happens with compatibility of uses. Now, if you're saying, well, there could be 5, 6 different uses that are acceptable in a given parcel, how do you deal with the usual relationships of amenity and just general compatibility and so on? The other aspects, I think, are probably well-trodden ground in terms of having a height parameter, density parameters, the circulation network that would be within the site. And then I think you're then coming down to the sort of the final pieces of green infrastructure, the drainage infrastructure that would need to go in. And also that might be the way in which you're able to also identify the important settings and so on that we may have on things like heritage and ecology that would need to be protected.
And given if it is correct that the 1990 Act is going to be largely or wholly untouched, and so the consequence of a growth area allocation is a 1990 Act style outline permission, then of course there will be scope for conditions. Effective plan is going to have each growth area will have its own little planning permission with conditions. I think one point about compatibility of uses, David, you meant they're going to have to modify the Pilkington principle, aren't they? The Pilkington principle for the uninitiated is where if you've got 2 planning permissions, whether or not outline or full, and the later one is, if implemented, will mean that the first one can't be built out in full. Effectively, it sort of somehow substitutes an element of it. Then that can, in some circumstances, mean the first one can't be built out. And you can see straight away how, if, for example, somebody was to get a specific, not a growth area permission, but a specific planning permission for something different, let's say a growth area, imagined a care home, and somebody came along and said, actually, I want a hotel there, then you could negate the whole growth area under the Pilkington principle. So they're going to have to modify that, actually, which is probably no bad thing.
Yeah, I think particularly sort of industrial type uses are the ones that would be more concerning. You know, old style B1 offices are not necessarily going to be a problem next to residential, but we're going to have these tensions of uses, and they're going to have to be resolved. Yeah,
absolutely. What about renewal areas? How do you see that working out in practice?
With the renewal areas, when I first saw the term, I got the impression that these were going to be about regeneration areas, whether it's sort of like collieries and dockyards and things like that, but it's certainly not the case. Those scale of developments would probably still come under the growth areas. So what this would be is more areas which are suitable for certain types of development, and then what's coming forward as part of that is that you wouldn't have an automatic planning permission, but there would be a presumption that if you were to fall into certain categories of development, then you would expect that you'd be able to secure a planning permission. Again, like the growth areas, the text to the policies is going to be able to identify the types of uses that are going to be acceptable, heights, densities, and so on. And I can also see that there's going to be the increased use of permitted development rights, which, again, there's this talk about pattern books and different types of development which should be capable of being acceptable in certain circumstances. So when I sort of look at the renewal areas versus growth, I would liken these more to be sort of the development management policies that you have within built-up areas. So the types of development that would be acceptable are the sort of infill development, redevelopment sites, densification is a word that's in the white paper, types of changes of use, town centre development, employment development. So the usual things that we've probably seen in local plans already, where we have permissive type policies in any event. And then I suppose what we're also going to have is every urban area is different. We're going to have sub areas within these renewal areas that might say, well, we've got one area of a particular type of character where this type of development may be acceptable, but something similar wouldn't be acceptable in another part of the town. And I think also in terms of the scale of development, I anticipate that we'll have some sort of cross-reference to settlement hierarchy, because it may be acceptable to have certain scales of development in a town, but not necessarily within a village. So we'll have different scales of development that's appropriate in those different locations. But certainly in the white paper, they're talking about built-up areas and villages as being part of these renewal areas as well.
And I can see, I mean, jumping ahead a little bit to the decision-making issues, but given the heightened presumption, so effectively if as I understand what's proposed, if a development is consistent with the vision for a renewal area set out with the plan, then some heightened presumption beyond the current section 38.6 presumption in favour of the development plan will apply. It seems to me two things are likely to flow from that. Firstly, there's probably going to be fewer appeals in relation to that kind of development. More stuff will get through local, ought to get through at local authority level. And secondly, local authorities that refuse permission in renewal areas, we're going to have to be very careful about their reasoning for doing so, because there's an obvious heightened risk of a cost award in that circumstance, it seems to me, if they don't, and particularly in relation to member overturns, because you can see straight away that there may be controversial things where officers explain that this is in a renewal area, is consistent with the vision, but members don't like it for whatever reasons. And I think the formulation of reasons for refusal and reasoning is going to be particularly important for local authorities in that context. Renewal areas, I think you're going to do this a bit of a double up with Gail, aren't you? Sorry, renewal areas, protected areas. Again, how do you see those playing out in practice?
In terms of the sort of geographical spread, it's very, very broad. It covers national parks all the way down to potentially back gardens being identified as being protected areas still. And what we're being told now is this isn't going to be left to the discretion of local authorities to decide what's acceptable. This is going to be set at national level. And it's talking about the type of development that would be allowed. And importantly, they're also using the word restricted in there. So it's very clear what's going on with that. The clear and obvious ones are going to be the types that we recognise from footnote 6 in the NPPF, those types of designations, Greenbelt, AONB, national parks, areas at risk of flood, designated heritage assets like conservation areas and local green space. So those ones are going to be very easy to sort of identify. The more broader ones that we're going to have is almost where they're saying if you're not in a growth area, not in a renewal area, then you're in a protected area by default. So it basically means all open countryside now is just going to be deemed as protected land. And it kind of sort of chimes back to the old PPG 7 type guidance that we had, where countryside was protected for its own sake. And I'm wondering whether we're almost going back to that sort of position. But what we've got to remember when we're looking at these sort of protected areas is, yes, they need to be protected for their intrinsic beauty and character and so on. But there's certain types of development that are essential in those locations as well. So how do we deal with things like renewable energy, where we might have solar farms, wind farms, which would necessarily need to be in open countryside? We've got tourism, leisure, recreation type development, which again is going to be required. And then we come down to the sort of age-old issue in residential terms. What about those communities quite often in large swathes of greenbelt and AONB? How do we meet their housing needs if these areas are going to be, in a primary sense, protected? So the other issue that I can foresee coming with this is sometimes it's very easy to say what it is that you're protecting. And you might say, well, it's this particular landscape here, it's this particular asset. But the one issue that I can certainly see coming up with heritage is going to be, well, how do you define the issues relating to setting, for example? And everything that we've seen in the white paper is talking about some sort of computerized approach, a map-based approach. And it's almost bringing down to the position, Gail, where, you know, do we have a cordon sanitaire around a listed building that says, well, that's its setting, and you define it by 60 meters, 100 meters? How do you deal with it?
You can't. Every setting is different. So, you know, they go far beyond visual issues as well. But even taking it as visual issues, then the one thing that setting certainly isn't is uniform around an asset.
Yeah.
It's particular to the type of asset as well. So some, say, a prominently sited house that's cited to have extensive views and be seen from a wider area is going to have a wider setting than a listed tombstone, which might reasonably be said to have a setting of the churchyard. So it's so dependent on type, and it's so dependent on lots of other issues as well. It is a really difficult issue. There are potential ways of addressing it in a more broad brush way, in terms of thinking about essential setting. But, you know, it should also be remembered that harm to heritage assets via their significance is not necessarily a showstopper. It has to be a public benefit test across all levels of significance and across all levels of harm. So it's a very nuanced issue that's difficult to reconcile with a map-based plotting approach.
And I think
the other issue that relates to that, I suppose, is conservation areas, for example. In theory, they'll be deemed as areas for protection, but we all know that they have gap sites, they have areas that are worthy of enhancement. And it goes, again, back to the statutory duties, where enhancement comes with development sometimes.
Yeah, I mean, any conservation area appraisal will have identified areas of potential enhancement. So,
Yes.
you know, development can be a massive opportunity to deliver benefits, not least heritage benefits. And, you know, they can come through enhancing the setting of the assets, enhancing conservation areas, and also, you know, better revealing their significance and understanding, which can be done in a variety of ways too. And it would be a massive shame to prohibit those approaches where they can be effectively delivered.
I mean, to my mind, all of this kind of boils down to what I think is one of the main uncertainties actually about the new world, which is the white paper talks about growth and renewal in permissive terms. In other words, things are going to be identified in the plan, and then it's going to be easier to put those things in effect than before. And that's the main prompt for the whole idea. But David, as you said, it seems that the protect area is going to be the rest. And the real question is, what, if any, level of prohibition or encouragement, or will it just be neutral, is going to exist in relation to development in those areas? Because there's obviously different layers of protection. It seems to me the protect area is not going to be one size fits all. There'll be effectively a swept over protect, and then probably within the protect annotation will be, if it's countryside alone, then you have to have regard to the intrinsic beauty of the countryside, what's now 170A, 170B, valued landscapes, etc., or the other way around. But if it's green belt, then very special circumstances needed, etc. If it's a conservation area, then you pay special attention to that. But that still there is the question: is the identification of growth in the growth and renewal areas intended to be complete or a baseline which can be exceeded? And I think if they can provide some steer that it's necessarily only a minimum, because you can't plan for everything, as we said before, that would be quite helpful in understanding what the future lies for the protected areas, particularly the less important protected areas, the sort of the general countryside. Otherwise, we're going to end up with countryside beyond the green belt coming back effectively.
Yeah.
Okay, well, let's just turn to, conscious of the time, let's just turn to the plan making. We've dealt with a lot of decision-making issues, right? But plan making, I mean, it seems to me the critical message in relation to plan making is, because the planning, the plan is going to be fundamentally more important than before, the engagement and process in relation to plan making is going to be more important too for those involved in the planning process. I mean, firstly, for growth areas, EIA, project level environmental assessment, and SEA are going to have to be blended, because you're getting a plan, but you're also getting a planning permission. There's obviously a forthcoming imminent consultation on reforming EIA and SEA, but effectively you're going to have one process to blend the two. As we discussed already, the List of Buildings Act would apply in this context, where previously it didn't. So it seems to me that you're going to have to, there's going to be an awful lot of issues which would have been dealt with at the application stage, which the promoters and indeed those opposing sites and local authorities involved in putting the plan together are going to have to deal with at the outset. For example, a heritage impact assessment of the nature that you would do in an application would have to be done for the growth areas. I think there's a number of issues with having, there's tactical considerations. David, do you got any sort of thoughts on the tactics behind that?
Yeah, I think following the sort of changes from local plan inquiries back in the day, when we would have emission sites that were being considered, we've already sort of started to evolve towards an approach where we're front loading the process. We're trying to in particular sort of bring forward site promotion documents, but here it's even more important. This is where you're going to get your allocation, your permission or not, and you can expect that everybody's going to be competing with you. And gone are the days of putting a red line plan in and saying, well, I think my site's suitable for 300 houses and let's just deal with it in the future. Now it's a matter of those site promotion documents showing that you properly understand all the constraints of the site. You've already got your technical consultants looking at the different issues to show that you're able to deliver the scheme. You would already be looking at sort of initial master planning concepts and how the site could come forward. And importantly, I think, particularly with these growth areas, it's being able to show land assembly and that consortiums are able to bring something forward that's meaningful rather than sort of ad hoc schemes. So I think it's going to be partly that you're going to be in competition with everyone else. This might even be your opportunity to try and knock the other sites to demonstrate why, in comparative terms, you're the best site. And I think councils are going to be inundated with all of these. And as we've found in recent years, it's those people who can put forward the most compelling case right at the start. Those are the sites that tend to last through the process as well.
And I think there's a degree of analogy with the reforms under the Planning Act 2008 for nationally significant infrastructure, the DCO process, which has made the process much more front-loaded. And the prize, if you like, in return for that document-heavy, front-loaded, expensive process was that once all the hoops had been jumped through at the outset, getting the DCO itself was something that stood a significantly higher prospect than getting a conventional application planning permission through the system previously. So
yeah.
I think there's elements of comparison there. I mean, I want to touch on examination briefly, and then we can move on to neighbourhood plans. But I mean, it seems to me that well, when I first read the white paper, I thought, how on earth are they going to do this in 9 months, which is the period they have proposed for the statutory cutoff for plan examination. But then you think about it, well, if you streamline plans, so you get rid of all the development plan management policies, because that's going to be done on a sort of national level. You get rid of the debate about housing numbers, because that's going to be dealt with before, and we all know that's what takes up the most amount of time at EIPs, and that's what causes the endless delay as authorities are told by inspectors to go and have another look. So you get rid of all of that, and what have you got left? You've got sites and areas, actually, and my experience of EIPs is that's something that doesn't get as much examination actually at EIPs as all the other stuff. So actually, in 9 months, subject to PINs and local authorities being given enough resources to deal with the intensity of that process, you can apply quite a lot of scrutiny in 9 months to, it seems to me, to the debate between which areas, which sites should go in which category, and what the adaptation should be for. So I think actually that if this works out as it's intended to be, you're going to have a more fine-grained analysis of competing sites than is currently possible in the local plan examination, which frankly is fairly superficial. I think we'd all admit, with the best will in the world. So I think and that sort of ties in with what you and Gail have said, David, about the evidence base having to be more granular as well. So I think also having discussed, for example, some of this with Simon Gallagher, the Director of Planning at MHCLG on Have We Got Planning News for You a few weeks ago, it seemed to me from that discussion, which I say was a public discussion, that the government does recognise that for the process to work and have legitimacy, there does have to be adequate scrutiny. They can't just sort of wave things through and tell people we're going to look at your representations in writing, we're not going to give you a right to be heard, etc. The big elephant in the room is PINs. I mean this, there's no criticism at all, but the task that they're going to have to face once this new system is in place is examining within a statutory 9-month window a whole country worth of LPA plans, roughly at the same time.
Yep.
And how on earth they're going to do that? And you know, it seems to me that the only way that's going to happen is that the government's going to have to provide them funding to make the government's new system work, and it may be that they have to get some part-time inspectors, because I'm not sure there are enough inspectors, frankly, to deal with all of that at the same time, and also deal with the day-to-day development control work. So that's the critical thing, and it is also obviously going to be critically important. I think again, MHCLG realise this, that a direction is given to PINs that they mustn't cut corners. There's some people think that the Rosewell review, which was intended both by government and by Bridget Rosewell to be about facilitating growth, has been interpreted in some corners of PINs as being all about timing. We'll dismiss your appeal more quickly. I'm not saying that's a fair comment, but that is certainly a comment that is said regularly, and it can't be thus in the new regime. It's got to be a process which is swift and efficient, but also applies adequate scrutiny. Otherwise, the whole house of cards will come falling down. Neighbourhood plans. A question has been asked about neighbourhood plans. They don't seem, the white paper doesn't seem particularly convinced of their merits, but hasn't quite got perhaps the political courage to do over them. What do you see the future neighbourhood plans, David?
Again, I'm a bit unconvinced. It's clear from the white paper that they're to be retained, and they clearly don't want to throw that out so quickly after spending years trying to bring them in. But I think when we look at what localism was really trying to do, it was tipping planning on its head. It was trying to get bottom-up planning. It was trying to make local communities take those difficult decisions themselves. And I think there have been some success stories, but I think it's been relatively limited. And I think the general view seems to be that they're often brought in to frustrate development rather than to encourage. So the fact that we've got a white paper now that is very clearly all about top-down planning again, bring in the housing numbers from above. We then have the local plan, which is going to be effectively identifying the growth areas, given those permissions. We'll have the renewal areas that are going to be defined. We'll have the protected areas. It kind of sort of asks the question, added to that, the development management policies are taken away as well, and a lot of that's going into national level. What's left for neighbourhood plans really to do? And I think the concern that I would have looking for them in the future is perhaps they're going to be more focused on design quality, and we sort of end up with sort of village design statements like we sort of had on an ad hoc basis in the past. So I think we have got that sort of relegation of neighbourhood plans. They're still going to be there. But I think the other issue that we often find is the timing of neighbourhood plans, that they often come in before the local plan and give you that problem of, have they prejudged the strategy by saying, well, you can't put any housing in this village or that village because that's already been dealt with in the neighbourhood plan. So I think that's an issue that would need resolving as well.
Absolutely. And I mean, I think it seems to me, I completely agree, David, that there's likely to be an opportunity for that, because if these new style plans are to be adopted within, I think it's 5 years is the target, if I remember rightly, may even be quicker than that, up and down the country, then to the extent that the new style local plans are inconsistent or move things along from adopted neighbourhood plans, then section 38.5 of the Planning Compulsory Purchase Act, assuming it's not tinkered with, will apply. And section 38.5 provides that when you've got two development plan documents within the same development plan and there's a conflict between the two, the later one prevails. Not in the context of section 38.6 balance, but in terms of is there accordance with the development plan? And so what that would mean is effectively there would be a potential for a widespread cleaning of the slate in relation to neighbourhood plans, because the new style local plans would come into play. That would be set the framework for development in each local authority area. And then there would need to be new neighbourhood plans providing whatever neighbourhood plans are going to be able to provide, which I think is a very good question you posed there, Dave, on top of that. But any old neighbourhood plans that might say you don't develop in this village, well, they'll be superseded if that village then is the subject of a renewal area. I think that it would be advantageous if there was some sort of statutory codification of a requirement for neighbourhood plans to come after local plans, because that's clearly what the logical intention is. It's the different layers of an onion. It puts the cart before the horse for neighbourhood plans to come first. So I think they're there to stay, it looks like, but I think they'll probably be their reach will be more limited than before, and probably the ability to frustrate development will be or to tie the hands of the local authority will be more limited than before.
I think if they could sort of come forward in the way that you've just described after the event, perhaps it's something that they could start to look at renewal areas as such in their villages and towns, and they could perhaps add to the types of development that could go in, as opposed to sort of trying to limit and frustrate anything further.
I agree. Let's turn to decision taking. We've kind of jumped ahead at a few points, and it's sort of inevitable because the two things tie up. Talked through a few of the points we were going to on decision taking. But again, from your perspective, David, in relation to growth areas, do you see the battlegrounds going to move towards reserve matters?
I'm not so sure, to be perfectly honest, because competing sites rarely have a go at each other at reserve matter stage. Local residents tend to have their major concerns dealt with at outline stage also, traffic, flooding, pollution and so on. So those issues tend to have gone by this time that they've in theory got their planning permission already through the allocation stage. So I think really the tension that we're going to have just in society generally is if we're giving up so much of the planning system in terms of control and abilities to get involved, and they're even talking about reserve matter applications being dealt with at a delegated stage, I think you are going to have increased focus on these design guides and design codes, and that will probably be the battleground where they'll be trying to make sure that they do get this building beautiful uplift in quality of development. Otherwise, they might think, well, this is just a way of bypassing us entirely. So I think that's going to be where the issue is. And then it comes also round to the usual sort of issues of, how do we increase supply by having all these different types of designs and so on? And this approach to pattern book, some people might say, well, how often are you criticised for standard house types when you go in with a reserved matter application? But if you're going to get the numbers up, and I think they talk about industrialisation of housing delivery, there will be standardisation, and I think it just needs to be of a decent quality. And as I said, that's why the design code and guides will be, that's where you'll uplift it, and people will then have to accord with it.
Absolutely, I mean, I agree. I mean, ultimately, if the likes of Persimmon aren't churning out 16,000 homes a year, they're not going to get the 300,000, are they? And they're not going to do the 16,000 a year without pattern books. It's simply not going to be standardised types. Now, Neil, housing delivery test is mentioned. We know that's still going to be there in some shape or form. How do you see that playing out? And also, what, if any, role might there still be for good old-fashioned 5-year housing land supply arguments?
Well, yeah, I mean, the current planning system broadly contains 3 measures to ensure that housing requirements are appropriately responded to. Firstly, local plans are required to identify a supply of deliverable and developable sites. Then the supply of deliverable sites is required to be maintained through a 5-year land supply. And then more recently, the housing delivery test has been introduced, which bites in relatively few instances, but it does provide a kind of measure in extremis. Even with that package of measures, the housing requirements in many cases still haven't been met. Now it's worrying, to my mind at least, that the white paper proposes to slim down the assessment of deliverability at the examination stage, which I would suggest is already too slim, but also remove the 5-year land supply. That seems to remove any imperative for an LPA to support or facilitate delivery, because there's no penalty for delaying delivery, and it precludes the necessary action to address any non-delivery through approval of other sites. So those are concerns which seem to fundamentally undermine the intentions of the white paper, and they're a real concern to me. The one thing that it does maintain, as Charlie correctly alluded to, is the housing delivery test, but that only works in extremis, as I said, and it only bites after 3 years of non-delivery. So it's a fairly ineffective measure of making sure that you don't just identify a housing requirement, you actually deliver against that housing requirement. And now, if it proceeds as it's proposed on that basis, I suspect the majority of development interests without sites in growth or renewal areas will just spend their time forecasting future housing delivery test results. And Pegasus Group already do that for a number of clients, to see when the windows of opportunity are likely to arise. But that doesn't mean that you're actually responding to need at the time. It means you're waiting for the opportunity to retrospectively fix a problem that should have been addressed a number of years previously. It's one of the few bits of the white paper that I have real concerns with, I'm afraid, Charlie.
Thanks, Neil. I mean, it seems to me that one opportunity for housing, for unplanned for housing development, whether relying on the housing delivery test or 5-year supply, or whether relying on a sort of classic Section 38(6) scenario, is where a growth area doesn't deliver the housing that's anticipated, because if it's, by definition, it's a fairly rough and ready, you're getting an outline permission, but by definition, fairly rough and ready process, you may not necessarily know precisely what the capacity is of the growth. So you have a guess, but it may, an informed guess, but it may prove to be less. I mean, David, do you see that as an opportunity for then, if a growth area, let's say it's envisaged by the plan, it would deliver 3,000 homes and it only delivers 2,700, that there may be an opportunity for someone to come in with a sustainable site to make up that gap?
given the language of the white paper, I suspect that they'll probably encourage us to go down plan-led approaches first, and it may be that we have alterations to plans which come in, but we've seen those, how long they take in the past to come about. The paper also talked about potentially having reserve sites, so you have those additional sites that could be brought in if there's necessarily a problem. And I think there's also the option of a bit more sort of extremist sort of safeguarded land being identified also, like that we would have had in the Greenbelt. So it kind of shows the directions for growth over an extended period. So we know where we would go if there would be a problem. But all of those approaches will take too much time. And I think the whole purpose of paragraph 11D and so on was to have an immediate safety valve that if it's not delivering, and as Neil says, we would have been going for 3 years then of non-delivery. So it needs to be something that's much more immediate. So I think that having a tilted balance presumption is still going to be important there. And that then is going to be, how do we then, presumably it'll mean that we'll have to go into the protected areas, and will those policies be required to flex? We'll always have, I think, that elevated status of Greenbelt and AONB, and I anticipate the very special circumstances and AONB paragraph 172 having to be rolled out in a similar form as before. But it's not to preclude development in those areas. It's just going to say that there's going to be those added stringent tests. So I think we're certainly going to need a safety valve of some sort. And if that's the case, I can certainly envisage that there's going to be an ongoing need for appeals. The paper talks about fewer appeals, but that's going to be a situation because you might have people that are refusing it for other reasons. And it still requires those judgments to be tested at appeals to see whether they're valid reasons for holding back development that's needed.
I agree, and I don't think it is all the doom and gloom that some people in some quarters have said in relation to unplanned for development, because if again, taking as a starting point that the basic structure of the 1990 Act isn't going to be, and in section 38.6, that it's not in the 1990 Act, it was in similar form in previous legislation, that the if something akin to in accordance with the development plan unless material considerations indicate otherwise remains the normal test, albeit a heightened test for renewal areas and automatic permission for growth areas, then even aside from the tilted balance, if the plan isn't delivering what it's meant to deliver, and if there's a site in a protected area but which is a low level protection, sort of countryside only, if you like, in a sustainable location, then it's always possible to make your case. And you're starting 1-0 down because you're not in accordance with the development plan. But if you can show why the material considerations indicating that you should get permission anyway, it will remain open to do that. And I think in relation to appeals, there are bound to be fewer appeals in number because I think certainly some smaller scale stuff in town centres and probably even homeowner type appeals will probably go down. And then obviously the big stuff in terms of the growth areas, obviously they're unlikely to generate as many appeals. But let's not forget that allocated sites never form the lion's share appeal work, really. It was always the hard cases, the cases where the developer was seeking to cut against the grain, or cases where the local authority might have had another look and not like something about a site.
You had a technical issue or something like that.
Technical issues, exactly. That the access, let's say that the access indicated in a plan is now ransomed and they're having to find a different access that has impacts. And those kinds of issues, they're still going to happen. They're still going to arise. It does seem to me that the proportion of appeals that are likely to be suitable for the inquiry process, and I'm not just saying this at a turkeys and Christmas thing, but the proportion is likely to increase. Honestly, I'm really not. But simply because they're going to be the cases which the newly streamlined, simplified system hasn't provided an answer for. So by definition, the proportion of complex cases going to appeal as opposed to straightforward cases will increase, because the straightforward cases ought to be getting permission or not need permission under the new regime. So I think if the system works well, we ought to see a higher percentage of appeals going through the inquiry process. I'm conscious of the time. We were going to talk about infrastructure, but I'm inclined to think that's probably a subject matter there. We might come back to if there are any questions. Does anyone have any final comments? Then should we work through? Conscious that we're 4 minutes overdue, but should we try and work through a couple of the questions that people have asked us before wrapping up?
Charlie, can I just come back on the topic just discussed on the appeals in protected areas, for example, or applications being determined? In the absence of a 5-year land supply, you don't have that trigger to say that there's been the non-delivery to necessitate the release of those reserve, or say that's the whole problem.
Yeah.
It's not just there to as a meaningless trigger. It actually brings about a response, and that's the concern.
Yes, yeah, no, understood. No, absolutely. And that's why it may, I got the impression from various things that have been said by people at MHCLG in various webinars on this, that they're not ruling out 5-year supply continuing to have a role as a default, or after a period of grace, a longer period of grace than the plans currently have for the recently adopted plan under paragraph 70 of the framework. Just looking through some of the questions, thanks to the people who asked. We probably won't have time to answer them all, but I'm not allowed to mention the names, otherwise the GDPR police will come and take me away to The Hague. But somebody has asked, for me, if in non-mayoral areas the supply target is by local authority area, how do you overcome the various problems of local government boundaries where you've got differences and quite considerable differences between local authorities, etc. I mean, I think the whole point of this process is it's going to be more rough and ready, and but the value of that is that you deal with housing requirement more quickly. So I think some of these problems are going to be inevitable, but the housing delivery area conciliation process that I've outlined, that I know is being looked at, that may iron out some of the wrinkles. So I mean, this gentleman talked about Swindonisation, so taking a large town or city outside of its surrounding rural or semi-rural area and putting it in another authority. I mean, I think the conciliation process of outline ought to hopefully avoid any completely egregious results, but there will be an element of a bit more rough and ready nature to the housing requirement allocation, because if you try and do it too grander, it takes, you get examinations in public lasting 3 years, and that's what this system is set up to try and avoid.
Charlie, I think there's a fairly easy answer to the Swindonisation point, that Swindon would be in a housing delivery area with Wiltshire, so there wouldn't be.
Yeah, that's right.
The urbanisation wouldn't be split between the two.
Yeah.
The needs of Swindon and Wiltshire would be considered jointly.
I've not heard the term Swindonisation.
No, I haven't.
I don't know, it's a term of art. Someone's asked if constraints are going to be considered robustly in relation to the housing numbers, should areas protected by policies relating to the quality of the land and protected by separate legislation be considered as a higher level constraint than Greenbelt? Well, it's an extremely good question. Yes, is my view. I think that, what would I say? The Greenbelt's obviously hugely politically controversial, and I can understand why the government might not want to say very much now until it's got the legislation in place, because if Greenbelt was overtly in the crosshairs of the white paper, it might affect whether they got the numbers in Parliament to get the necessary legislation through. But I think what the person who asked this question has rightly identified is Greenbelt has no statutory underpinning in terms of the protection afforded to it, and therefore actually once the new regime is up and running, if the government wanted to say, for example, that housing need is capable of, is an exceptional circumstance, or if it was to say, that the expectation in relation to constraints is that no local authority should lose more than, let's say for the sake of argument, 15% of its greenbelt in any one plan, or 10% or whatever the figure was, but up to that, up to a certain percentage, it shouldn't be treated as a constraint, then they could do that in policy. They wouldn't need to change the law. Whereas, of course, if you wanted to downgrade the protection given to SSSIs, AONB, national parks, you'd have to change the law. So actually, there's a bit more flexibility for the government to be cute on Greenbelt if they want to. And I'm not going to get into the politics of whether they should or shouldn't, and whether they will want to. I think we've dealt with the question on neighbourhood plans. Someone's asked, should PINs be abolished and their budget given to local authorities to build up capacity to support young planners to pick up the workload? I'm not going to alienate every tribunal I appear in front of by telling them to do their job. I think being serious, PINs has a fundamental role in making this new regime work. It won't work without PINs being able to deliver the examinations with the necessary speed and rigour, and some form of organisation reform is going to be needed to deliver that, and that's no criticism of PINs. That's simply a reflection of the fact that they're a public sector body with finite resources and they need more. So I think some pretty radical injection of resources is going to be needed for PINs, but I don't think they should be abolished.
And importantly, they're independent as well.
Yeah.
Rather than diverting the resource to a local authority who will clearly have an agenda in relation to every planning application.
Absolutely. Although, I mean, the local authorities are obviously going to face immense resource challenges themselves. In fact, probably more than PINs, because they've got to do all the hard work to get the plan before PINs. It's going to be a huge challenge for them. I'm just reading the additional question. While a local plan examination may be simplified by taking policy numbers out, much of the delay on major applications to process agreeing the details with officers, departments and stakeholders such as Natural England, Historic England. Is this unsuitable for the examination process? And I think this is asked in the context of growth areas. No, I think it could be dealt with. I mean, ultimately, Natural England and Historic England would tend to be input into and consulted on plans anyway. In fact, for the SEA of Sustainability Appraisal, Strategic Environmental Assessment of Plans, Natural England, for example, is a legally necessary body to consult on the scope of the SEA. So I think it could be made to work. I mean, again, the resources issue comes up. How are Historic England and Natural England going to provide timely and informed consultation responses to over 300 local plans? So I mean, it's the same answer. It's going to be a lot of hard work, but I don't see it as in principle something's going to be impossible. Under the proposals, it's expected the outline consents in growth areas will include a means of access, or that be left as a reserved matter. My understanding is that everything will be left as reserved matters, so there won't be full permission. It's a good question, actually. It's not something the white paper deals with overtly, but certainly having heard people like Chris Katkowski outline what they envisage, and Chris kind of wrote much of that part of the white paper proposals. I don't think that what is intended is a full permission for access, but
I think it would probably be like the procedures order at the moment, that if access isn't identified, then you could at least indicate the location of where it would be with an arrow on a plan.
Yeah, exactly. That even if you didn't get full permission, you could resolve much of the doubt, couldn't you? Because you could indicate this is where it's envisaged it would be. Net biodiversity gain, is that going to be a major constraint on allocating sites? What do you got? I mean, I've been involved in a few cases where it's already been put forward, even though it's not yet a requirement. I mean,
it's the calculator, the matrices, isn't it? And is it sort of a 10% minimum requirement now that's going to be imposed, which I think it'll just have to be built into schemes, and that's that.
I mean, I'm thinking through in cases where it's come up. I can think of one case where I've advised on, and what the ecology said, it'd be very hard to get 10% on this particular site. But then the inquiry I did last week, the uncontested evidence was we were going to deliver 29% by net biodiversity gain.
Yeah, I've seen it both ways like that. But I suppose in circumstances where we're moving away from 106 and SIL regulations, what's to stop there being a bank of biodiversity enhancement that could be off-site?
Yeah,
so,
absolutely.
You're still delivering it, but not necessarily on your particular site.
Absolutely. I mean, harder, I'd have thought, in relation to urban sites. You know, the renewal areas will probably find it harder to achieve net gain than growth areas. Ultimately, if you've got lots of fields on which farmers have used fertilizer for years, it's not difficult to get a net biodiversity gain on that. I I think that's all the questions. I'm conscious it's 2:15, so we probably better wrap up. Thanks very much to those who have stayed throughout, of which there are many of you, and thanks to those who have had to go, but maybe might be catching up on YouTube later. I think this is going to be on YouTube or some platform. It'll be fascinating to watch it in about 5 years' time and see if anything we've said turned out to be true. Hopefully, we'll have hit the mark on a few in few respects. Thank you all, and we'll let you know when we have any further seminars of this nature. Have a good afternoon. Cheers.